question would be how to deal with unfavorable facts when we represent a client as lawyers or as members of a national delegation before the International Court of Justice. How should we deal with unfavorable facts? And what I've seen from law students and even from lawyers, at least in Guatemala, is that there is sometimes this tendency to say, oh, we won't mention this. This is too unfavorable for us. We won't bring it up. Or we should only deal with it if it is brought up during the hearing, but otherwise we're not dealing with it. And I like to provide an example or a comparison. Say that I had a car accident, I crashed my car, and we want to know what happened. And then I go on over and over saying that, well, I was driving, the light was green, I had the right of way, but then there are certain empty whiskey bottles in my car, which were found at the scene of the accident. And I only talk about the green light and the speed limit, but I refuse to talk about those whiskey bottles. That could be a possibly unfavorable fact, because it could mean that despite my apparent compliance of the law, I could probably have been drunk at the time of the accident, and that, or had been under the influence of alcohol. And that would change things significantly in determining responsibility. However, there are different ways of telling the story about the bottles, right? I could say, well, those empty bottles are bottles I used to produce artisanal honey. I have my own bees. I produce milk. I'm sorry, not milk, but honey. And I was just carrying them for the purpose of filling them up with honey later. And so I'm a hardworking man, which simply happened to have an accident. Or you could say, no, I mean, this guy was actually drunk. This guy had emptied down 2 bottles of whiskey and he crashed. Yeah, as you can see, there are 2 different ways of telling that story, right? But these bottles could be a very relevant element to that story. And if I avoid discussing about those bottles, then I could maybe not be doing the best possible work for my client, right? So this question on how to deal with unfavorable facts leads me to what a case theory is, and then we'll discuss a little bit on how to build a case theory. So basically, when we talk about a case theory, we're talking about a story, the story of what happened in a given case, in a particular case. It involves both a legal and a factual theory, right? Not only what happened, but also what that implies legally. And it should always be a detailed, coherent, and accurate or very precise account of what happened. So in a nutshell, the case theory you have to present when you argue a case is a detailed, coherent, and accurate account of what happened. And of course, what that implies legally, right? So you will combine your factual and legal theories. Now, there are certain aspects you should take into account when building a case theory. One of them would be a case theory should always be based on strong facts and inferences that can be fairly drawn from these facts. This is importantly relevant if you are deciding how to present a case theory, but not in the situation of a moot court case. A moot court case will give you the facts. And yet, a moot court case will always leave a certain room for ambiguity. So you got to make sure that when presenting your arguments, they are based on solid facts on the record or the company. A case theory should be built on facts not subject to much or any dispute. It should be consistent with any incontestable fact, right? You could build a magnificent case theory and present wonderful legal arguments, but there is an incontestable fact that will make it irrelevant or will make it not appropriate. Say the empty whiskey bottles. Was I drunk or was I not drunk? You should address that. Your case theory should address that in that case of the car accident. Otherwise, it's probably an incomplete case theory. It should also take into account and explain away as many unfavorable facts as possible. When doing a moot court, usually cases are drafted in such a way that there will be some favorable facts for one party, some favorable facts for the other. But it is your job to really try and take into account as many facts as possible, and especially those which might seem unfavorable. And this is particularly relevant because those are the facts that judges or panels are likely to ask about during your hearings. So you really need to prepare in such a way as to be able to address those apparently unfavorable facts. Your case theory should be accepted by the trier of fact, in this case, the court, the tribunal, without having to stretch the imagination, right? Oh, since we're talking about this type of agreement, it is reasonable to think that there was also a non-disclosure agreement associated to this contract, right? An NDA. Well, but can you produce the NDA or not? Or are you asking me to imagine that there was? So this is also very important. You need to use the compromise. You need to use clarification questions in a just of competition, but do not ask the judges or justices to stretch their imagination. Oh, but we can suppose such and such thing happened. And it should also not be based on wishful thinking about any aspect of the case, right?